The court system is one of the most important parts of our judiciary system. In the early days, the king's courts sought to establish a common or uniform set of rules for the whole country. As the number of courts and cases increased, portions of the most important decisions of the year were gathered together and recorded in yearbooks. Judges settling disputes similar to the ones that had been decided before used the yearbook as the basis for their decision. If the case was new, then the judge had to create new laws, but they based the decision on the general principles suggested by earlier cases. The book of judge-made law that developed under the system is still used today and is known as common law. The practice of deciding new cases with reference to former decisions became the cornerstone of the English and American judicial systems. Our judiciary system has changed vastly over the last 200 years and yet is still governed by the same set of laws by adding amendments. These amendments are what give our government the flexibility that it has today. The Constitution is the supreme law of the land. A law in violation of the Constitution, no matter what its source, may be declared unconstitutional and thereafter cannot be enforced. The Constitution thus defines the way our state and federal powers are reconciled. It is up to the courts to decide what a constitutional provision or a statutory phrase means. Ultimately, it is up to the Supreme Court. In doing this, the courts establish our laws. The very first bill introduced in the United States Senate was the Judiciary Act of 1789. It divided the country into 13 judicial districts. The 1789 Act called for the Supreme Court to consist of a Chief Justice and only 5 Associate Justices, and for the court to meet or sit in the nation's capital. For the first 101 years of its service, Supreme Court justices were required to ride circuit, holding court twice a year in each of the 13 judicial districts. The Act also assigned the power to nominate Supreme Court justices to the President of the United States with the approval of the Senate. The Supreme Court was first called to assemble on February 1, 1790, in the Merchants Exchange Building in New York City, then the nation's capital. The first Supreme Court was made up of Chief Justice John Jay, Associate Justices John Rutledge, William Cushing, James Wilson, John Blair, James Iredell. Each year, the Supreme Court receives over 7,000 petitions from parties seeking review of their cases. These petitions do not result in automatic appeals. Just because a party wants to take its case all the way to the Supreme Court, the court will not necessarily hear the case. The Chief Justice leads the meeting in which the justices discuss the petitions and vote aloud on which cases they find more significant and deserving of deliberation. To be considered, a case must receive at least 4 votes. In deciding whether to review a case, the court will generally consider whether the legal question was decided differently by 2 lower courts and needs resolution by a higher court, whether a lower court decision conflicts with an existing Supreme Court ruling, and whether the issue could have broader social significance beyond the interests of the 2 parties involved. Lacking any specific direction from the Constitution, the U.S. judiciary spent its first decade as the weakest of the 3 branches. The first Supreme Court was not sure it had the power to consider the constitutionality of laws passed by Congress. This changed drastically in 1801 when President John Adams appointed John Marshall of Virginia to be the 4th Chief Justice. Marshall took clear and firm steps to define the role and the powers of both the Supreme Court and the judiciary system. The Supreme Court then defined itself with the historic 1803 decision in the case of Marbury v. Madison. In this landmark case, the power to interpret the U.S. Constitution and determine the constitutionality of laws passed by Congress and the state legislatures. During his time, Marshall is given credit for molding the federal judicial system into what is considered today to be the most powerful branch of the government.